Pretty sure that's fine, so I think we are good to go. And good afternoon, good evening, and good night. And yes, I knew about the hot mic, but it was a bit of fun. How are we doing, people? Happy... Oh, what are we? Today is Monday, so it'll be Sunday for the people in the US. For anyone asking, or well, for anyone that's wondering, Costco was good. Had the hot dog, put some relish on it, which was interesting. I'd never had that before, but yeah, certainly made things interesting. Right, today's show is going to be a little bit different, mainly because we are going to be talking about topics from the rainbow. We have a individual that is suing in order to reinstitute pride in a certain county. We have a man that's been extradited from Queensland to Melbourne, we have a man that's been extradited because of a body found in a metal container. We have a TikTok murderer who is apparently still managing her social media from behind bars. And China's expanded the 7- line to a 9- line, now a 10- line. But before all that, we're going to talk about Spotlight. We're going to talk about 7 News' documentary that aired last night and how it's ruffled a few feathers. But let's get stuck into it, shall we, people? Welcome to Law, News and Laughter. Okay, good. That did not redo. Now, for God's sakes, if anyone's watching over on Rumble, I have popped out the chat. I didn't ignore you guys yesterday. I actually had the chat sitting in front of me. For some reason, it didn't reload. So, for God's sakes, if any of you are over there and I'm not commenting or anything, pop back over to YouTube. Let me know that I need to reload it, okay? But otherwise, I don't know until comments start coming through or whatever. Now, the Spotlight interview. Well, the Spotlight documentary. I didn't watch it. I'll preface that straight off the bat, because I want to watch that with you guys so that you can see my initial reactions. It's the same reason I want to sit down and watch the one about the sex cult, that apparently there's people brainwashing young ladies here in Australia and sending them off to Korea, which is the other reason that I wanted to have Jeff involved in that one. Yeah. Oh, crap, hang on. Yeah, no, that's fine. All right. So, but let's... so Spotlight is... how do I explain it? It's like a news documentary series. I mean, but it is mainstream media, so, take it with a grain of salt, whatever else you want to call it. Think of it as like an episode of 60 Minutes, but with a little bit more credibility. Just. So, but let's have a look at this article, which is Daily Mail. So again, Jeff's already involved in that one. There's been jokes. All right. Hang on. Where is my preferred? There we go. Transgender surgery regret. 7 News Spotlight airs claims medical industry is violating vulnerable young people struggling with their identity. Oh, damn it. I forgot the stinger. Ha! Gay! Okay. Transgender surgery regrets. 7 News Spotlight airs claims medical industry is violating vulnerable young people struggling with their identity. A woman who had her breast surgically removed to try and become a man now feels she was violated by the medical industry and made a mistake that left her worse off. Mel Jeffries was born a girl and grew into an unhappy, depressed teenager who, like many teens, was confused about her identity and sexuality. Hang on, what's going on there? Why can I not? There we go. She thought her life would be better if she transitioned into a male and lived as a man called Mason from the age of 18. Okay, 18, don't have an issue with that. With testosterone treatment, Miss Jeffries had a deeper voice, facial hair, more muscle and weight, but it wasn't enough. All my hatred, damn that's a strong word, of being a woman was just a focus on my chest, she told Channel 7's Spotlight program. So age 26, he had his breasts removed. See, we're over the age of 18. We're well into our 20s. I have no issues with this whatsoever. This is an individual who is making their own choices, presumably with the appropriate medical advice. Somehow, she now considers one of the greatest mistakes of her life. She now considers this one of her greatest mistakes of her life as she transitions back to female. Well, you made the choices. That's your own. Spotlight claims there are thousands of vulnerable young Australians who regret changing from male to female or female to male. I don't doubt it. Miss Jeffries describes her life as a clusterfuck, and she will always carry the scars, physical and mental, of the choices she now regrets. When she was 16, she said she was just looking for a sense of belonging and found comfort in online communities. Oh, good. Rumble chat's working. When she was 16, when she was just looking for a sense of belonging, online community. Yeah, okay. So, I don't know that you can blame online communities, especially at 16. Where the hell were her parents? The internet's doomed an entire generation. No, poor parenting has doomed an entire generation. And now we've got schools that want to cut parents out entirely. And then it's like, if you do transition, it's like, oh, everyone gives you so much love, she said. Yeah, because that's just twisted. Before making decisions, she now regrets she had been through quite a few experiences. I was SA'd, and I feel like it was a big fuel of me wanting to transition and not be a woman anymore. Where the hell was the mental health support on this? Miss Jeffries thought being a woman made her vulnerable and an easy target, and that she would be better off being male. The magical thinking was like, I could be someone and I wouldn't have to be me. I wouldn't have to deal with everything that came along with my life, she said. Maybe all my unhappiness is because I was born in the wrong sex. The online community was almost like the love of a new family in supporting her transition. Yeah, because they told her exactly what she wanted to hear. She was told there's your biological family, there's your family you don't choose, and then there's your logical family, the ones who choose you. Because now everyone's a Pokemon. Starting on testosterone was easy. She was prescribed it in a diagnosis that took less than an hour. Miss Jeffries felt that she'd been encouraged to begin the process because she was primed by others into thinking if you don't transition, you're going to kill yourself. Holy shit. If you're just priming people to do this to hurt themselves. She realised she made a huge mistake after the double mastectomy when, ironically, someone called her Mason, the name she was already living by for 8 years. That just felt so foreign and alien. That name just felt so disorientating to me. She wants other people to know the pain she's gone through. I'm never going to be over it. They're wounds, they're not even scars. It's like I'm still bleeding. Holy shit. I'm still processing it and grieving. I've literally been violated by the medical industry. Miss Jeffries is not sure if she would like to be a mother, but would like to meet someone to share her life with. For now, she's focusing on her health and being comfortable being a woman. Well, I'm female. It's not just that I'm a woman. It's like my sex is intrinsic to my experiences. Being female is intrinsic to who I am. Earlier on Sunday, Channel 7 was criticised for using photos of transgender influencer Grace Hyland in a promotion for the Spotlight episode. Here we go. Here comes the, snowflakes coming out of the woodworks. I'm not particularly, across what 7 News did, but I can understand a little bit of why people are upset. But, okay, can I just put it out there? Looking at this individual, you wouldn't necessarily know that they were trans. Unless they specifically, I don't know, unless you hear her voice and maybe whatever. I can see why she would have no regrets. Miss Highland, 20, used her TikTok account to slam the network after making it seem she regretted changing gender. I transitioned at 13 and don't regret it at all. Well, you may be one of... You might be happy with that. But you were 13. I'm glad it worked out for you, but for thousands of others it doesn't. Adding that she had breast augmentation surgery 2 days earlier. Wait, what? Oh, so she's just had her boobs redone. Okay. Even though my face is in this, I don't agree with it. I don't stand for this story. I don't stand for the sensationalism of the whole thing. Don't get it twisted, Channel 7, she said. There are over 1,000 adolescents on waiting lists for gender treatment across Australia. Oh, for fuck's sake. Where's this video?
Probably like through puberty, I had like quite a few experiences that were negative. Like I was sexually assaulted. And I feel like that was quite a big fuel for me wanting to transition and not be a woman anymore.
Because you felt what being a woman was making you vulnerable?
More vulnerable and like an easy target. I thought that I was safer within like a male identity. They're wounds, they're not even scars. So it's like I'm still bleeding.
Oh, Jesus.
I'm still like processing it and grieving. Like I've literally like been violated by the medical industry.
Greetings, everyone. My name is Dr.
Oh, piss off, Fauci. How did that even start? That's the one thing I hate. It does not fix when I actually do that. So I should probably just do that rather than have half my face cut off. So yeah, so that was part of an excerpt from the Spotlight documentary. We will eventually be watching that. I'm going to watch that over on Rumble just because A, YouTube doesn't like copyright, and B, I don't need to get myself yeeted off YouTube. But yeah, that's sort of the reality of it, and it is quite disturbing at times. But moving from one tail of the rainbow to another, there is now a lawsuit going on. A drag queen is suing a Tennessee DA for threatening to shut down Pride. Yeah, so being threatened for words. But anyway, drag queen Flamey Grant and the organisers of the Tennessee Pride event are suing a prosecutor who threatened to enforce the state's drag ban against them, arguing that officials are violating their constitutional rights. Yeah, so they're probably going to be making a free speech claim here, but in the claim, Grant, filing as Matthew Lovegood, and the organisers of the Blount County Pride alleged that Tennessee Attorney General Jonathan Skrmetti, District Attorney General Ryan Desmond, and 3 other law enforcement officials infringed on their rights to free speech, called it, with a recent letter Desmond sent regarding concerns about a planned September 2 Pride event. As first reported by journalist and legal analyst Chris Guider, Desmond wrote in the letter that he planned to enforce the state's Adult Entertainment Act, which attempts to ban male or female impersonators anywhere a minor can see them, even though a federal judge issued an injunction to prevent another prosecutor from using the vague and overbroad law earlier this year. The letter and the defendants Chris and Desmond's further attempts at intimidation are a naked attempt to chill plaintiffs' free speech and expression in retaliation to Blount's Pride social media posts promoting the event, the complaint alleges. The plaintiffs, represented in part by the ACLU of Tennessee, are seeking damages and another judgment declaring the AEA is unconstitutional, as well as a temporary restraining order allowing Blount Pride to go ahead this weekend as planned. Oh shit, I should have actually read this a couple of days ago, because when was this? This was the 31st, so this was over this weekend. Oh, I wonder this actually, hang on. What was it? Blount Pride. Did it go ahead? Okay. Okay, so there was festival celebrates. Okay, so there were protests, and there was. Okay, so we do have a resolution to this as well. This is why I should do a little more research instead of sitting on news articles. Okay, Threatening to enforce this unconstitutional law amounts to a harmful attempt to remove the LGBTQ people from public life, which is simply unacceptable, said ACLU Tennessee legal director Stella Yarborough in a statement on Thursday. The court has made it abundantly clear that drag performance is constitutionally protected expression under the First Amendment, regardless of where in the state it is performed. Judge Thomas Parker's prior injunction did not specifically enjoin Desmond by name from enforcing the law, and was issued in Tennessee's Western District, which does not include the county. But the complaint argues that because Parker issued his decision against one official representative on the state, it applies equally to all other Tennessee prosecutors and DAs, a legal concept known as privity. Pride organisers wrote on Facebook on Thursday that while they were concerned about how the current circumstances will affect Saturday's Pride, the event is still planned to move ahead as scheduled, and Flamey Grant doesn't plan on spending the day at home. Drag is an ancient art form, and I have seen how it can help build community and hold space and connect people, the Queen said in an ACLU press statement. Sometimes I have trouble reading these, I'm not going to lie. What you do in your own house is your deal, don't put this in front of kids. Look at that, I have mail. I joined this lawsuit to ensure that I can continue performing in Tennessee because I have seen how drag speaks to people who simply want to belong and be loved, making them feel safe and supported. That's all I want my art to do. Okay, so that's fine. So do it in a private place where individuals are welcome to go, and it's not in front of kids. It's really not that difficult. Around 100 inmates have taken over part of Minnesota's saltwater prison. I wonder how they'd feel about drag being around children. Saltwater prison. Okay. Anyway, let's have a look at the court documents, shall we? Action is brought under Title 42, Section 8, 1983, and is premised on the First and 14th Amendments. Who's shocked? Parties and personal jurisdiction. Don't really care about any of that. Factual allegations. In October of 22, Jackson Pride planned to host its third annual Pride Festival, celebrating the diversity of the LGBTQ+ community in Jackson and West Tennessee. As part of the festival, Jackson Pride planned a family-friendly, appropriate for all ages drag show. Oh wait, my audio's not working. What the? Nothing prevents drag shows. I just want it to be seen by children because, yeah. Interesting how they demand to be seen by children. Why is my soundboard not working? Oh well. Part of the festival. Drag is defined as clothing more conventionally worn by the other sex, especially exaggerated feminine clothing, makeup, and hair adopted by a man. Drag is usually performed as entertainment and often includes comedy, singing, dancing, lip singing, or all of the above. Drag is not a new art form, nor is it inherently or even frequently indecent. Drag has been present in Western culture dating back to ancient Greek theatrical productions, where women were often not permitted to perform on stage or become actors. Instead, male actors would don women's attire and perform the female roles. The earliest productions of William Shakespeare's plays also featured male actors in drag playing the female roles. By the 1800s, male or female impersonation was known as drag. The vaudeville shows of the late 1800s and 1900s popularized drag or female impersonators. One of the most well-known female impersonators, Julian Eltidge, made his first appearance on Broadway in 1904. By 1927, it had become specifically linked with the LGBTQ+ community. Really? And by the 1950s, drag performers began entertaining in bars and spaces that specifically catered to gay people. In the decades that followed, drag solidified itself as an art form. Although drag is still centered around and holds specific historical significance for the LGBTQ+ community, the art form is now definitively a part of mainstream culture. One is likely to find straight people at a drag show as gay people. RuPaul's Drag Race, a drag competition television show, has won 7 Emmys and is currently in its 15th season. The show has spin-offs in the UK, Australia, Chile, Thailand, Canada, Italy, Spain, and elsewhere. Like all forms of performance art, drag encompasses a vast spectrum of expression. Okay, so this is just going through the history of drag. Where are they at? Where's the actual factual allegations? In spite of the benign content of the Jackson Pride drag show, some members of the local community took issue with the event being held in a public park. After public backlash, city officials and members of the Pride Committee agreed to move the event indoors, but for some people this was still not enough. Tennessee State Representative Chris Todd, along with State Senator Ed Jackson and members of the First United Methodist Church, filed a lawsuit in Madison County Chancery Court asking the court to declare the drag show a public nuisance and permanently enjoin the city of Jackson from granting a permit to Jackson Pride organisers. In the complaint, plaintiffs argued that a drag show, no matter how benign its contents, is an adult cabaret, and therefore should not be permitted within 1,000 feet of a church. With the date of the event just around the corner, Jackson Pride agreed to make the event age-restricted to those 18 or older. Jackson Pride maintained that the event was family-friendly and appropriate for all ages. In his comments to the press, Representative Todd stated that this is not something we agree with and it's not something our children need to be exposed to. It's about protecting kids in the community from something harmful to them that is not age appropriate. Now this is straying into territory I'm not comfortable with. If the event was age restricted to over the age of 18 and it was indoors in a private facility, they're calling everything involving wearing different clothing as drag. Shakespearean actors weren't doing BDSM or even exaggerating female roles. That is a good point. That is a very good point. Although Jackson Pride organisers had repeatedly stressed that the drag show was thoroughly vetted to be family-friendly, with no lewd or sexual content allowed, Representative Todd insisted the drag performances were clearly meant to groom and recruit children to this lifestyle, and that is child abuse, and we will not have that here. When pressed about how he knew it was child abuse if he'd not actually inquired about the show's content, Todd replied, "This type of performance and its content is child abuse." I think moving forward, we anticipate that any kind of consideration of a drag queen event be non-existent, and that they would realise this community has no place for that. The problem is the sexualised nature of it. Yeah, and I agree with that. My own personal opinion is that I don't class it as any different to, say, a strip show. So unless they're banning those as well, provided the same requirements are put in place, as I said, it's an 18-only event. They'd probably have to have security, obviously, checking IDs and things like that. Banning it outright, though, how religious is Tennessee? I have no idea. Tennessee already has state laws prohibiting obscenity or indecent exposure in front of minors. Representative Todd was not seeking to enforce those laws. Instead, he sought to prevent any drag entertainment, no matter how G-rated, from being performed in front of children merely because he personally disagrees with the content. In response, after violating the First Amendment rights of Jackson Pride, Todd was asked to come up with the legislation that would make this much more clear. The drag performances in front of children are a violation of Tennessee law. In January of 2023, Representative Todd introduced House Bill 0009, which would amend the TCA to ban any adult cabaret performance in front of children that appeal to the prurient interests of minors. It's a Bible Belt state. Okay. The law was later amended to cross-reference the definition of harmful to minors from the TCA, which regulates in part the sale and distribution of pornography and of other sexually explicit content to minors. When asked on the House floor why the law was necessary if such conduct was already illegal to perform in front of children, Todd stated that the bill was intended to cover conduct like that which he dealt with in his own community the past year. When asked on the House floor if he knew of any instances of children being harmed by adult cabaret performances, that's sort of irrelevant. Todd recounted how his lawsuit forced Jackson Pride to move the family-friendly drag show indoors and apply age restrictions, and explained that's exactly how the bill is structured. It doesn't prevent those performances, but it certainly says they must be not held in front of minors, and we intend to uphold that and expect law enforcement across the state to uphold the principle and to uphold what we pass here in the legislature. The buckle of the Bible Belt. Todd's bill did pass the legislature and was signed into law by Governor Lee on February 27, 2023. So the text of the bill is: an offence for a person to perform adult cabaret entertainment on public property or in a location where the adult cabaret entertainment could be viewed by a person who is not an adult. Okay. So your Bible, I wonder how people would react if there was a spontaneous Christian event for all ages. I would expect they wouldn't Not just sexual, children are not even supposed to be allowed to into R-rated movies for various reasons. Well, yeah. Adult cabaret entertainment means adult-orientated performances that are harmful to minors, the term defined in subsection 39.17.901. And that features topless dancers, go-go dancers, exotic dancers, strippers, male or female impersonators, or similar entertainers. I see no issues with this. Includes a single performance or multiple performances by an entertainer. Harmful to minors means that quality of any description or representation in whatever form of nudity, sexual excitement, sexual conduct, excess violence, or sadomasochistic abuse when the matter or performance will be found by the average person applying contemporary community standards to appeal predominantly to the prurient, shameful, or morbid interests of minors. Is patently offensive to prevailing standards in the adult community as a whole with respect to what is suitable for minors, and taken as a whole lacks serious literary, artistic, political, or scientific values for minors. None of this should be around minors. Okay. In March of 23, drag-centric theatre company Friends of George, Inc., FOG. Oh, come on. You couldn't make it Friends Assisting George? I'm going to regret that one. I am going to regret that one. Oh, I just realised my camera's so badly off the side. There we go. That's better. FOG filed a suit in the Western District alleging the act is unconstitutional. FOG sought injunctive relief against Shelby County District Attorney Steve Mulroy. FOG alleged that the act was facially unconstitutional under the First Amendment for several reasons. Okay, I don't really care about the other case. Law prohibits such performances in a location where adult cabaret can be viewed by a person who is not an adult. There are no defined locations in the law. Prohibition is not limited to commercial establishments or paid performances, which means a drag performer could be arrested for providing free entertainment at a family birthday party held at that family member's house as long as children are present. If a restaurant hosts an 18-plus drag brunch and children walk by and see it through the windows, nothing prevents drag performance from being charged under the statute. There is no affirmative defences included in the law and no exceptions for minors who see drag shows with parental consent. Well, that shouldn't be an exception anyway. I mean, whilst I do believe that parental supervision is important, I mean, in today's day and age, you just can't trust it. And that's really terrifying, actually. This means there are 31 potential definitions of prohibited conduct. There is no way for a performer to know what is and is not specifically prohibited from district to district. What is strange is I know some older people in their 60s who are not offended by those words. Oh, no shit. Severity of criminal sanctions may well cause speakers to remain silent rather than communicate even arguably unlawful words, ideas, and images. Okay, so they're talking about the chill of the speech. Law also opens up any establishment or even a private home that hosts drag shows to police raids so law enforcement can be certain no children are present at the event. Yeah, I don't like that. Indeed, even after Jackson Pride agreed to move their family-friendly drag show indoors and restrict attendance to 18+, Representative Todd told the press that the event will be carefully monitored by the police department to watch for violations. The fear of felony charges and an uncertainty about what could give rise to those charges will certainly keep the citizens of Tennessee from engaging in protected speech. I'm calling such bullshit on this. I really am. So federal courts already declared the act to be unconstitutional. On the 2nd of June 23, after full trial on its merits, the court issued a finding of facts and conclusions in Friends of George v. Mulroy. Its 70-page analysis found that the act is a content-based viewpoint discriminatory regulation and that the act is not narrowly tailored to achieve Tennessee's compelling interests. Additionally, the court concluded that the act is unconstitutionally vague and broad. Court granted FOG both declaratory and injunctive relief against the DA. Court declared the Adult Entertainment Act is an unconstitutional restriction on free speech and permanently enjoined the DA from enforcing it. Okay, so now we got the enforcement of the acts by the plaintiffs. Age restricting the event, they outfoxed Mr. Todd. Well, that's just the trouble. It doesn't look like that was enough. I I can't even wrap my head around this. I don't understand why it's such a big issue. Sorry, guys. I'm also well aware that me sitting here staring at a screen is not particularly entertaining, but I also don't necessarily want to voice the thoughts going through my head right now. Hey, Jay, how are you? As if that act is the only thing that's vague and broad. If it's unconstitutional to be vague and broad, then the EPA, the TFA, and Firearms Act need to be removed. Prevents that DA, not another DA. Well, the argument is that because of privity that all DAs are enjoined, because it's an official position as opposed to an individual. I think that's probably a stretch, but anyway. Blowout Pride Inc. is a 501c3 non-profit that organises and hosts an annual Pride Festival in celebration of the community. The festival hosts live entertainment, including drag performances by individual entertainers. Excuse me. Blowout Pride's third annual festival is scheduled to begin Saturday, 2nd of September. Currently has no age restrictions on the event, and there are events specifically planned for children, so individuals under the age of 18 will be present on the premises. Okay. No age restrictions on any of the events, and they specifically have events planned for children to entice them to engage. That seems completely different to the previous event. Matthew Lovegood is a drag artist who performs under the name Flamey Grant. Plaintiff Lovegood is scheduled to perform in drag at the Blount Pride this year. On Tuesday, 29th of August, just 4 days before the festival, Blount Pride received an email from the district attorney stating that please see the attached notice regarding the officer's prosecutorial position relative to the Adult Entertainment Act. The accompanying 3-letter page is annexed at Exhibit 3. I really wish the exhibit was attached. In the letter, the defendant, Desmond, asserts that he intends to enforce the act despite a federal court ruling in the Western District of Tennessee declaring the act unconstitutional. Upon information and belief, the defendant, Desmond's decision to enforce the act relies in part upon the opinion or advice that the Attorney General, Jonathan Scarametti, that the district's court applies only to the district attorney for the 30th district. That's the problem. They're so hell-bent on making sure children see them. If they cared about being accepted and bringing people together, why do they focus on kids? That's a good point. I'll be honest, I don't think kids should be allowed in Hooters either, so that's fair. That's what I'm... I don't think it takes much for an objective observer to decide what is actually sexualized and what's not. And the trouble is, because as bad as it sounds, individuals in the community are not self-regulating, shall we say. You get the images of the guys wearing leather and dog masks and driving down the street on the back of a truck, shaking their naked ass at kids in the audience or whatever else. God, see, I don't even want to think about that shit. I really don't. Took a photo of my son at 6 months old with a Hooters girl. That's a bit different. Hooters isn't a man in a strip club focused on kids is. Yeah. Defendant Desmond states the letter is a direct response to a coming event planned for September 2 that is marketing itself in a manner which raises concerns that the event may violate certain criminal statutes within the state of Tennessee, and the letter aims to put potential parties on notice of possible ramifications of criminal conduct. The Pride promotional material, including social media posts on Facebook and Instagram, explain examples of which are attached. The post includes lists of vendors, planned entertainment, photos of entertainers, including several photos of the plaintiff Lovegood's drag persona Flamey Grant. None of the posts are sexual in nature. Defendant Desmond also addressed the letter to 3 law enforcement heads. I'm not going to read all that out. Defendant Desmond's decision to include the law enforcement officers in the letter empowers and encourages police to enforce the unconstitutional act. The act chills the speech of the plaintiffs and any person in Black County who is subject to the jurisdiction. So I bought my newborn a future Hooters Rooter jumpsuit when I was in the States. The missus was not impressed. Difference is the Hooters girls don't want to have sexual relations with the kid. Might be hitting the nail on the head there. Okay. Upon information of belief, Defendant Chris contacted Maryville College, requesting Maryville College provide a copy of the contract between the plaintiff, Blount Pride, and Maryville College. The next day, Defendant Chris called the president of Maryville College, notifying of Desmond's letter and asked to arrange a meeting between them. Maryville College referred to Maryville College's legal counsel. Upon information belief, counsel for Maryville College was subsequently contacted by the defendants Desmond and Chris later that day. During the call on August 29, they also notified the officials that Maryville College, including Mr. Croker, could face prosecution for a misdemeanor if they violated the act. While defendant Desmond claims that we do not prematurely evaluate the facts or evidence related to potential investigations, he also states that his office conducted a diligent search to find a way to seek prior restraint against Blount Pride. It should be noted that at this point, a diligent search of relevant statutory authority has revealed no mechanism under which District Attorney General of the State of Tennessee could petition for temporary injunction to enjoin an individual or group from organising or holding an event that would violate the AEA. Yeah, okay, so they've done their due diligence. What's your problem? It only took DeSantis like a week to catch family-friendly drag Christmas events simulating deer and pull the bar's liquor license. I wonder if someone did a search for drag performances by everyone involved to see if they actually do child-friendly content. Well, see, they're sort of claiming that these individuals weren't actually able to decide what was child-friendly and what wasn't because the event hadn't actually taken place. Okay, so they're arguing that the declaration in the previous case applies to them. Okay, so what do they ask? What are they after? Plaintiff incorporates and alleges all facts. The defendants seek to explicitly restrict or chill free speech. Violation under the First Amendment, retaliation against the defendant. Violation under the 14th Amendment for vagueness. Okay, so they're basically just making the same arguments. So they asked for leave to amend the complaint after reasonable discovery, grant the plaintiffs a temporary restraining order and preliminary injunction, enter a judgment declaring the act unconstitutional under the First and 14th Amendments. Yeah, so they were looking to make the act apply as broadly as possible to every, but past performances, if they do exclusively adult entertainment performances, I wouldn't believe they would start one now for this event. It's a good point. Okay, so what actually happened? All right. Blount County DA blocked from enforcing anti-drug law ahead of Pride Festival. So in the space of 2 days, it was heard before the court, and the DA lost. Federal judges blocked an East Tennessee district attorney from enforcing a state law restricting public drag performances after he sent a letter to the organisers warning they could be prosecuted if they violated the law. U.S. District Attorney Judge Ronnie Greer granted a temporary restraining order against the DA from enforcing the EAE Act, Adult Entertainment Act, the AEA, a state law that bans adult cabaret entertainment on public property or where children could see it, which was ruled unconstitutional by a federal district judge in West Tennessee in June. Ahead of a planned celebration of the LGBTQ+ community on college campus of Maryville College, Desmond sent a letter to the organisers and officials asserting that the judge's ruling did not apply in the district and that he was prepared to prosecute any potential violations of the AEA in any event. His letter prompted a lawsuit from the ACLU on behalf of Blount Pride and drag performer Flamey Grant, arguing the letter was a naked attempt to chill constitutionally protected free speech. Had defendant Desmond merely wished to notify the public that he intends to enforce the law, he could have issued a public statement, the lawsuit says. Instead, he sent a letter targeting Blount Pride and drag artists who are scheduled to perform. All parties in the lawsuit have been ordered by Greer to appear at the federal courthouse in Greenville for a preliminary injunction on Friday, 8th of September. So this coming Friday, there's going to be a further thing. Okay. Wonder how these weird mums that take their kids to these events would feel if they dropped Timmy off at a friend's and mum was in her bra and panties dancing in the game room. Also, Barton Bella, well done for getting me to say the P word on stream. I did not see that one coming. This is why I got to read properly. Say that many of the drag shows I've seen or heard in Tennessee are just entertainers playing a role like Dolly Parton and other singers. Nothing bad. Fair enough, Cindy. Gyrating your dong and twerking your brown starfish at children is not a free speech issue. And I think that's the problem here. That's really the problem that I have here, is that there's a clear difference between what is sexualized and what is not. Like, legitimately, if it is an individual who is just dressing up and it's not... what am I trying to say here? If there's no sexualization about it, then I don't see that necessarily being an issue. What I have an issue with is what we're all familiar with and what gets blurred and rolled into all that. Like those parades that I'm talking about. Like, where it's a frigging, like, drag strip show and you've got a 4-year-old child walking up and sticking a dollar bill into an individual's, like, underwear line. I don't even want to say that anymore. Makes kids start questioning. I don't care if they're dressed up as a Queen of England. It's not just sex. Okay. Well, anyway, we'll have to wait until Friday to see exactly how that one pans out, because the judge issued the temporary restraining order to allow it to go ahead over the weekend. And we'll have to see exactly where that one pans out, so... No, I didn't want to open that. God, I'm going to have to get used to that. Alright, let's move on to something else, shall we? A man has been jailed after suing Will County for $20 million. Lockport resident Santino Mussolami, acting as his own counsel, also sued Romeoville, Lockport, and the Illinois State Police in August. Yes, he looks like the sharpest tack in the shed. The 42-year-old Lockport man filed a $20 million pro se lawsuit last week against Will County for banning him from the downtown Deloitte Courthouse Annex property. He's now in police custody, and he will be placed in a treatment program administered by the Illinois Department of Human Services. Judge John Connor ruled. Oh shit! John Connor became a Well, no, Barton. It's not that I can't say it. It's it's like saying moist. Last week, Will County State Attorney's Office asked Connor to modify a treatment plan for him, placing the Lockport man in an inpatient treatment program through the Illinois Department of Human Services. The Will County judge placed him in DHS care, but ordered him to remain in the custody of Will County Sheriff's Office during the period required to determine the appropriate placement by the provider of treatment. The individual was booked into Will County Jail without bail last Thursday on charges of unlawful violation of an order of protection. The Romeoville Police Department originally arrested him on violation of protection charges back in March 22. He's remained in custody until April 22, jail logs show. In that case, according to Will County court records, he was accused of stalking a woman. Stalk a woman and then claim $20 million. Yeah, okay. Just don't put the two words together. Yeah, probably not. Like saying juicy and moist because it makes so many people uncomfortable. Yeah. Yep. Prior to the arrest, he was a regular visitor to the courthouse, where he filed multiple civil lawsuits without the use of an attorney, seeking millions of dollars in damages against Romeoville, Lockport, and now Will County government. In the Will County Annex, law enforcement recklessly defamed me by using the system to digitally store licenses, ID photos, and posting in the lobby the photo of my Illinois driver's license to show the public I was not allowed in the building. The word banquet makes me cringe. Banquet? What's wrong with banquet? I love a banquet. Oh wait, no, I'm thinking of buffet. Sorry, I just had something run through my head. Never mind. Okay, so they took a copy of his license and posted it to say that he wasn't allowed in. Also, the county continues to maliciously prosecute a politically charged case. I'm suing for defamation and malicious prosecution. At the bottom of the document, he filled out his name and prays for $20 million in cash relief. This month, he also filed a civil lawsuit against Lockport on August 3, seeking $10 million. Since 2004, I've made multiple notifications to the municipality about our family's connection to politics and the campaigns against my family, he put in the Lockport lawsuit. constant civil discourse has resulted through negligence from Lockport, Illinois government. On August 3, he also filed a $5 million lawsuit against the Illinois State Police, seeking the reinstatement of his FOID. In that lawsuit, he wrote that he is asking for a federal investigation into the Illinois State Police collecting medical information from the Lake County Health Department and using it to violate civil rights Title 18, 241 in a conspiracy against rights. Asking to charge the Illinois State Police with wire fraud for unlawfully collecting medical information through the electronic means which violates the HIPAA. In his August 3 lawsuit against Romeoville, he wrote that he's seeking financial compensation of $5 million. On May 12, 2021, he claimed the Maricopa County Superior Court received a letter from Romeoville that was based off of a preponderance of a thought instead of actual rules of Arizona criminal procedure or Arizona statutes. The defendant may cite Illinois State Police guidelines as the cause. However, that does not release the municipality of vicarious liability. I'm asking for financial relief due to civil discourse caused by the letter and a violation of Title 18, Section 241, conspiracy against rights. Jaron Fury, fuck you. Okay. I think this guy may need medical assistance, that's all I'm saying. Does he know what frivolous means? See, you know what the irony is? The irony is that for the most part, this guy would still not meet the burden for frivolous and vexatious litigant. Because with all the jargon that he's thrown in there, there's enough there that it may be a trialable legal cause. Like, don't get me wrong, it's not going to go anywhere, but there's enough there that it may still have to sit in front of a judge, which I think is just hilarious. But anyway, what's wrong with his eyes? I wish I knew. An Abomination, I'm not reading that one out. I'm sure he's got brown irises, but he does look like he has no irises whatsoever. All right. Okay. Man extradited from Queensland to face charges after body found in metal container. Yeah, this one's a bit on the nose. A man has faced court charges being an accessory to murder after the discovery of a 22-year-old man's body in a metal container in New South Wales mid-north coast earlier this year. Charles Dennis Turnbull, 33, appeared in the Lismore local court on Saturday after being extradited from Queensland on Friday. Mr. Turnbull was arrested in Brisbane in May after an investigation... Wait, what the He better have been on... okay. Was arrested in Brisbane in May after an investigation into the discovery of Darcy Schaefer Turner's body in a large metal cabinet on a property at Waller Creek, south of Maxville. Police said the application for Turnbull's extradition was granted by the Brisbane Magistrates Court on Friday. The 33-year-old was taken to Tweed Heads Police Station, where a warrant was executed for the alleged offences of accessory to after-the-fact murder, improperly interfering with a corpse, and to steal a motor vehicle. Mr. Turnbull did not apply for bail, which was refused in court on Saturday. He will next appear before the Sydney Downing Centre local court on September 5. The discovery of Mr. Schaefer Turner's body on May 12 came after a missing person investigation. A 22-year-old man was arrested in South Sydney in May, charged with his murder. The case remains before the court. I'm curious to see exactly what he did to interfere with the body. Probably moving it. Actually, no, that won't be the case, because otherwise then it would be transporting a body. Is there a proper way to interfere with a corpse? No, there really... Well, actually, yes. Morticians and funeral directors, like, in the course of their business, will generally interfere with a corpse, but as it's part of their occupation, it's not considered to be interfering with a corpse. And most places will actually have legislation in relation to that. So there's that. Where are we? Putting it into the container. Yeah, look, that's probably it, actually. Thinking about it. I don't know. This was more just a small filler one, I'll be perfectly honest, but I was more interested to see the extradition stuff, and they didn't have any of the paperwork, which I'm really frustrated about. But anyway. Alright, let's move on to the TikTok murderer, who's apparently still active on TikTok despite the role in killing 2 men. The TikTok account of an influencer jailed for murder along with her mother was still active on Friday despite its noted role in the killing of 2 men. So what, they're having a go at TikTok for not having taken the account down, or... Okay. The TikTok account of an influencer jailed for murder was still active on Friday despite its role in the killing of 2 men. Wait. The account was involved? Mahek Bukhari... I know I shouldn't be laughing. 23 hatched a plot to silence Saqib Hussain, 21, after he blackmailed her over sex tapes. I remember reading about this a few months ago. She and her mother, Anne Sreen, 45, arranged to meet at a Tesco car park and got others to jump Hussain. His Skoda was chased by 2 cars containing 8 people, including the Bukharis. He died with friend Hashim Ijzuddin in a fireball after being rammed off a major road near Elisha in the UK. Judge Timothy Spencer, KC, pointed to the negative impact of social media, telling Bukhari, "Your tawdry fame has made you utterly self-obsessed." Oh, I'm not so sure that it was just social media that made this chick utterly self-obsessed. You'll have Crocs, best cleanup of a murder one can find. He's just an idiot. Actually, Eris, for the most part, if you know what you're doing, pigs. Hogs, really. Wild hogs will do it. TikTok is still alive, so no one murdered it yet. A month after her conviction, her profile is still live on TikTok, where she has 134,000 followers. Anti-violence campaigner Alison Cope, whose 18-year-old son Joshua was stabbed to death in 2013, said it's not acceptable. Social media platforms need to take more responsibility. Here we go. On Friday, Mahek Bukhari was jailed at Elisha Crown Court for at least 31 years. Her mum got a minimum of 26 years. TikTok has declined to comment. Footage has since been released by UK police showing how Bukhari spun a web of lies to officers after the horror in Leicestershire as the pair were convicted of the murder. Just 4 hours after the crash, police attended the home in Stoke-on-Trent to arrest the pair. Bukhari, wearing a pink fluffy hoodie, can be seen perched on the edge of a sofa as she tells officers, "So at first we stayed here and then went straight to Nottingham." When asked if they went in her Audi TT, she agreed with police. But Bukhari and her mum had not been to Nottingham, but instead joined the other defendants in murdering Saqib and Mohammed. The killers travelled in 2 separate cars, Bukhari's Audi and a blue seat Leon, to follow then ram the pair in their silver Skoda. In her police interview, the web of lies continued to grow as she gave a fake version of events. An excavator can dig a hole over 30 feet deep, just saying. Claiming to be a very good driver, she claimed she was driving with her mum when the Skoda cut in front of her and the Seat. Bukhari told officers she slowed down after her mum told her to keep your distance. Smirking, she said the car was agitating the blue car and it's just harassing, and this silver car was not letting the blue car go. I went past and got further away, and then the blue car caught up with me. All I heard was a bang and the silver car hit the blue car. I said to my mum, "What's going on? Are they drunk? What are they trying to do to the blue car?" Bukhari claims that there was another bang and she didn't see anything, just looked at her mum in shock. In reality, she and the blue Seat had chased Mohammed and Saqib in their Skoda, not the other way around as Bukhari had suggested. During the 160 kilometers, so 100 miles per hour crash, passenger Saqib had called 999 as he pleaded for help. He said, "I'm being followed by 2 vehicles. They're trying to block me in. I can't get to a police station. I need help right now. There's guys following me. They've got balaclavas on." Way to be stereotypical about it, guys. "They're trying to ram me off the road. They're trying to kill me. I'm going to die." After giving his name to the operator, Saqib then begs. They're hitting on the back of the car very fast. "Please, I'm begging you. I'm going to die." This is a case of road rage gone bad. No, this was intentional. From memory, this was a... he'd been dumb enough to try to record them having sex, and he was threatening to release the tapes. So she arranged for some of her fans to assist her in permanently removing the problem. She, however, is claiming that it was road rage, yes. He can then be heard screaming before the clip cuts off. Moments later, the car the friends were travelling in smashed into a tree on Central Reservation and split in two. Jurors were told the horror smash was no ordinary traffic offence. Instead, it was a story of love, obsession, extortion, and ultimately cold-blooded murder. Saqib had been in a relationship with the married Anne Serene for about 3 years and appeared to be in love with her. Isn't that the mum? Hang on. So we're down here so I can get back to that. It was her mother. He was dating her mother. During the illicit tryst, he splurged £3,000 or $5,800 on Anne Serene, who he called Anzie on date nights. Oh, good God. By January 22, the mum was trying to end the relationship, but increasingly obsessive Saqib would not accept it was over. As a result, he took to attempting to blackmail her by threatening to send their sex tapes to her husband. Oh. On January 4, Mahek Bukhari sent her mum a message which read, "I'll get him jumped by guys and he won't know what day it is." The TikTok influencer also messaged her mum's ex-lover telling him, "I'm sorry that this year you'll be gone, Saqib." She and her mum hatched a plot to silence Saqib, with her mum luring him in by the offer of getting his £3,000 back. On February 10, he was driven by a completely innocent friend Hashim to collect the cash from Leicester. Leicester? Nah. Shortly after, the pair were killed in the fireball crash. Mahek Bukhari and Anseen Bukhari denied 2 counts of murder and 2 alternate counts of manslaughter. Both have been jailed for life with a minimum term of more than 31 years and 26 years, respectively. Following defendants Rekhan Kawan and Reez Jamal were also found guilty of 2 counts of murder and jailed for life. Natasha Akhtar, Amir Jamal, and Sanaf Gula Mustafa were all found not guilty of murder, but guilty of 2 counts of manslaughter. Mohammed Patel was found not guilty of murder or manslaughter. So there you go. Maybe just don't announce your intentions if you're going to do it. Just do it. Jesus, that is in no way legal advice on this channel, Just Dawn. Oh, God. So, it was the mother, too. That's the weird thing. But yeah, so basically, social media star uses friends to try and, yeah. Fuck's sake, people blame social media platforms and are not the broken mental state people are in. Hey, sometimes social media can be very much a crutch. Sometimes it gives you purpose. Just saying. But yeah, that chick still is going to enjoy her time behind bars. Pretty little mouth like that. Oh, fuck, I shouldn't have said that. Oh, well. Montana Fish and Wildlife Park saying an angler has killed a grizzly bear in self-defense. This is pretty freaking, like...
In area news, an angler killed a grizzly bear in self-defense this week in the Tom Minor Basin. According to the Montana Department of Fish, Wildlife and Parks, the incident happened this past Wednesday on private land along Tom Minor Creek. 2 anglers were walking through dense vegetation when they were charged by the grizzly. One of the anglers shot and killed the bear. No people were injured. FWP says the adult male grizzly's behavior
that's not how it was billed to me when I read the headline.
Close encounter. That incident's still under investigation. In area news,
oh, piss off. No, when the headline that I read was he killed it like melee style. So that's okay. Anyway, all right. China's new map release infuriates Taiwan, India, and maritime neighbors because, you know, they went from the 7- line to the 9- line, and now it's the 10- line. And it's just encroaching further and further. China has released a fresh map showing a 10- line demarcation on the South China Sea and other territorial claims in the region, igniting a fresh wave of opposition from its neighbours. China's Ministry of Natural Resources released the new map on August 28, notably with a line on the east of Taiwan, which Beijing considers a renegade province. We received news that the now 9- line has been extended to the 10- line, Philippine President Ferdinand Marcos Jr. told reporters on Friday as he vowed to continue defending his country's territory. Taiwan and Vietnam also aired objections, joining India, Malaysia, and the Philippines. The growing chorus of opposition to Beijing's latest move comes days before world leaders gather in Indonesia for meetings of the Association of Southeast Asian Nations. Asian. And later in India for the Group of 20 summit, where the territorial dispute may be discussed. The map reinforces China's claims to land and waters from its neighbours, from the Himalayas to the South China Sea, said Lucio Pilto III, a visiting scholar at the National Chengchi University's Department of Diplomacy in Taiwan. It also reiterates Beijing's position over Taiwan. The map is directed to both domestic and international audiences, he said. For many years, Beijing has asserted that nearly the entire South China Sea, stop calling it the South China Sea, and it might remove some of the legitimacy. I've been saying that for how many months? Yes, Mandy, I'm well aware that I'm Australasian. We're not going to attack China. We've got our own problems. For many years, Beijing has asserted that nearly the entire South China Sea, marked by the so-called 9-dash line, is within its territory, an assertion that overlaps with separate claims by Brunei, Malaysia, the Philippines, Taiwan, and Vietnam. Well, of course they're going to ignore Taiwan, but at a 2016 international arbitral decision that invalidated the expansive claims didn't stop China from reclaiming and building on those maritime features. The Philippines described Beijing's 2023 map as the latest attempt to legitimize China's purported sovereignty and jurisdiction in maritime features that the Philippines also claims, while Vietnam said the map violates its sovereignty over the Spratly and Paracel Islands. Taiwan also opposed the territorial claims outlined on the map, saying the island has never been under the control of the CCP. Taiwan is absolutely not a part of the People's Republic of China, Foreign Ministry spokesperson Jeff Louis said in a briefing on Thursday. No matter how the PCR distorts its stance on Taiwan's sovereignty, it doesn't change the objective fact of our country's existence. While neighbours expressed their outcry, Indonesia's Foreign Minister, Retno Marsudi, said the country's stance on the issue isn't new. Whatever boundary, whatever claim has to comply with UNCLOS, she said, referring to the United Nations Convention on the Laws of the Sea. Look at this shit. So China's all the way up here. You got Vietnam down here, you got the Philippines here, Malaysia here. China is claiming everything in this area as being their sovereign territory. So apparently they're claiming, Vietnam is part of China, Taiwan's part of China, Hainan, although I think that actually is. This is some bullshit. On Tuesday, India said it lodged a strong diplomatic protest over the map, which shows parts of the Indian state of Arunachal Pradesh under China's control, expanding from a move in April to rename 11 areas of the region as part of southern Tibet. Aksai Chin disputed a disputed plateau in the Western Himalayas claimed by India, but controlled by China was also included. China's Ministry of Foreign Affairs spokesperson Wang Wenbin didn't directly respond to the question about the 10-dash line during a regular briefing on Thursday, saying that China routinely publishes maps for public awareness and use. Point at Hanoi on the map quick. Hanoi, it's right there. Why is that a... Which point? We hope that relevant sides can see that in an objective and rational way. Yes, it's a totally objective and rational that China is taking out a huge swath of land that doesn't belong to them. I'm sure everyone's going to see that in an objective and rational way. Fuck off. The 2023 map won't make much of a difference to China's behaviour in the South China Sea, according to Pilto. If anything, the new map may offer another justification for its claims and activities in hotspots like the South China Sea. Nobody owns it, see? Oh, you're using the fact that I can point to something Asian on a map that I'm Asian? Nice, Mandy. Nice. Okay. Okay. I also want to talk about something that's relatively important, but I'm just going to touch on it briefly because I do want to do a full episode specifically on it. For anyone that doesn't know, the Australian Capital Territory, where we have our our federal parliament. It's basically Australia's capital. It's Canberra and like an area of, I think, about 2,500 kilometers, 1,100 miles or something around the area, half of which is national forest. Just saying. The entire territory has about 400,000 people in it. The territory parliament there has decided to more or less decriminalise all illicit substances for personal use. Setting aside the fact that that's more or less really only going to apply to the politicians that are staying there and, 400,000 people that assist in the running of the place, because, let's face it, why else would you be in Canberra? It seems like rules for thee and not for me, particularly given that the federal health minister is also looking to ban nicotine vaping. But all of a sudden, individuals in the Australian Capital Territory will be able to walk around with heroin on them or cocaine on them, MDMA, meth. These are all things that, provided it's under a certain amount, they'll be allowed to walk around with for personal use. If they're found with anything greater than that, it's anywhere between a $100 and $160 fine or a referral for drug treatment. Just saying. So, but anyway. All right. Scare tactics. Criminal defense lawyer slams moral panic over ACT drug decriminalisation. A recent push to decriminalise cocaine, heroin and ice in the Australian Capital Territory has sparked a reaction as old as time itself from the police, who's shocked. Come October, Canberra will become a drug fantasy land, according to the Australian Federal Police Deputy Commissioner Neil Gowan, who this week warned that people flooding the city for the weekend cocaine escapades is a reality that we can't ignore. Former Liberal Party Vice President Tina McQueen was also highly critical of the ACT government, describing it as a dangerous move. But in the eyes of informed observers, Australia is way behind the times. Countries like Portugal, which decriminalised drugs over 20 years ago, are reaping the benefits, seeing little to no increase in recreational drug use, while also cleaning up the courts for trials of minor first-time offences. Now, I've always been a big proponent of regulation over prohibition. People are still going to do stupid shit. If the government wants to, they might as well make money off of it rather than just throwing people in jail, costing taxpayers, because prisons, for the most part, aren't privately owned here. But that's... now I know where to go. But again, when you've already got the rest of it being outlawed across Australia, I'm not really a fan of this. Oh, Angel Australia, thank you for the $10 super chat. Just because, thank you very much. I hugely appreciate that. I will announce some various things in relation to super chats and that sort of thing in the next couple of days. For anyone that is watching that didn't know, I have been sort of thinking about how I can retool things, make things more interesting. Particularly having sat through this morning's show, I do apologise. Even I'm bored. I'll be perfectly honest. And I'm not sure if that's just because I've got things on my mind or if it's just because it was a slow news day. I just want you guys to be entertained. And I'll admit this morning I don't feel like I'm pulling my weight. But thank you all for watching. I hugely appreciate it. Be prepared for mentally ill people walking around high, break-ins to increase, social services to skyrocket. Well, we shall wait and see exactly what happens. Drug-related deaths have remained below average since 2001, with the proportion of prisoners sentenced for drugs falling from 40% to 15%, all while the overall rates of drug use in Portugal consistently remain below the EU average. So when the Deputy Commissioner threatened action against those carrying a minuscule amount more than the new legal amount, decriminalisation advocates were furious. We'll be seizing drugs, and if anyone has anything that looks slightly more than what's allowed, we will lock them up for supply, he said on Monday. It's a reality we can't ignore. Joseph, you won't measure that shot glass coward. That's a new one. Okay. Sounds like a tall tale from an imaginary company. Oh, a country. Don't even get me started. What? Just took a walk on the Mexican market and it began raining. Raining in Texas. Dude, what? It was raining? Interesting. We'll be seizing the drugs of anything that looks slightly more. That's not okay, really. I mean, like the point of the police is that they're there to enforce the laws that are agreed upon and that are actually put out. That's I don't like that. There's a lot about this that I don't like. For many, it's a bit like listening to a broken record. Criminal defense lawyer Adrian McKenna criticized what he believes to be a moral panic, claiming that the staunchest critics of decriminalization are simply in the dark about the benefits on wider society. There were similar concerns when they decriminalized cannabis over becoming a target. Massive concerns over untold harm and a massive spike in drug use, but it's hardly a cannabis fantasy land. It's a bit more of a focus on drug diversion. Decriminalization has been seen by some as a more mature approach to the problem by understanding the inevitability of drugs being present in Australian communities. Well, there is that. And focusing efforts on tackling issues of addiction and abuse as opposed to disciplining offenders. Lucky I wore a black short. Yeah, it doesn't really matter when you don't wear a bra, Mandy. Focusing on efforts of tackling issues of addiction and abuse as opposed to disciplining offenders. McKenna said he was tired of seeing the same old cases come through the door, stating that it would please me nothing more than to waste time on cases of small-time offenders. What? Decriminalisation would in large part remove a large amount of the unnecessary court proceedings, according to McKenna. There's also the scaremongering over Canberra, a one-bikey town, becoming something of a crime hub. That messaging is completely unhelpful, and it doesn't promote what they should be focusing on, a smooth transition. The reality is a lot of drug possession cases are young people going through an experimental phase. That can mean a criminal conviction that hangs with them for 10 years. Is that really what we should be focusing on? It's been working just fine with the cannabis. Mr. McKenna said a focus on removing the stigma around drug use would do a lot for the overall health of the nation, emphasising the need for governments to provide to better promote treatment options instead of locking away youths. One potential benefit is destigmatising drug use for people to come forward and look at treatment options seriously. Mr. McKenna urged the Deputy Commissioner and others who hold similar views to rethink the issue and refrain from immediately dishing out threats to the public. Yeah, I don't agree with that. I don't like the way that the cops automatically came out, brandishing the batons and saying, yeah, if it's over the 0.5 of a gram or whatever, you're going to jail sort of thing. Weed and meth are a fuck of a lot of different. This is true. I hope all of the ice heads move to ACT. It would be great. Change the language you're using. This is going to be a process. The words matter. We should be thinking carefully about the words we use as we move forward. We need good community messaging. We need to move away from crime and punishment and scare tactics. However, anyone hoping to see similar changes rolled out in neighbouring parts of the country will have to wait. In the wake of the ACT announcement, New South Wales Premier Chris Minns ruled out discriminalisation, revealing his government had no plans or mandate to follow Canberra's lead. The New South Wales Labor Party promised it would hold a drug summit during its first term, but has now swiped decriminalisation off the table, at least until the next state election. We need to let the drug summit do its job, but we don't have a mandate to decriminalise. I couldn't do that without the support of the people of the state of New South Wales. Decriminalised amounts of drugs will cost someone a fine from the ACT from October. Oh, it's 1.5. My apologies. Hang on. Look at this. So you can have 50 grams of pot, 1.5 grams of MDMA, 1.5 of ice, 1.5 of cocaine, 1 gram of heroin, 1.5 grams of magic mushrooms, and 0.001 gram of LSD, and 1.5 grams of meth. That's how much you can walk around with in the ACT, basically. Words hurt. Did you hear how states over here that legalised marijuana banned hemp? Totally not a bunch of drug companies greasing politicians' palms to control markets. Well, I mean, the whole point around why hemp was originally banned was the... can you have it all at once? Yes, you can have all of that individually on you at once. The whole thing with hemp was that it was in competition with cotton. So, PRB going into anonymous mode. Okay. So, but anyway. All right. Moving on to the final big story of the day, because I've got about a half hour left. This one I found interesting because, so now for claims of sexual assault, people are basically turning on a dime and claiming that individuals are using what's been called as the DEP defense, which I think is a bit disgusting personally. A GMU law professor is suing his former students in a $108 million defamation case. His defense is similar to Johnny Depp's, apparently. Their lawsuit may be BS, but their ranch sriracha peanuts were great. Grab these nuts, put them in your Wrong show, amateur iconoclast, but thank you for the super chat. I'm just saying, neither of them look even remotely similar. Just saying. A former law school professor is turning to an increasingly popular legal defense strategy after multiple students accused him of using his position of power to pressure them into romantic and sexual relationships. Joshua Wright, a former commissioner for the Federal Trade Commission and former professor of law at George Mason University, denies the allegations and has filed a defamation suit, which I just realized I didn't have open, against two students who accused him of misconduct after they took their concerns to legal news outlet Law 360. He's seeking $180 million in damages, citing lost business and humiliation, embarrassment, and mental anguish caused by the accusations in a defensive maneuver. Legal experts told Insider has become the go-to playbook for people accused of abuse following high-profile cases like Johnny Depp v. Amber Heard and the countersuit of Donald Trump v. E. Jean Carroll. So his defense is that it literally didn't happen. Yeah, so basically what he's saying is it didn't happen, but more to the point, he's turning around and suing for defamation. And that's what they're now calling the Depp defense, which I think is pathetic. They should not be twisting that. The accusations against Wright. Two of Wright's former students, Elsie Dorsey and Angela Landry, told Law 360 they felt Wright abused his power as a professor and coerced them into a romantic and sexual relationship with false promises of career advancement and opportunity in exchange for intimacy and companionship, and that the professional opportunities were withheld from them when they refused his advances. On the one hand, that is horrible. On the other hand, welcome to reality. Not that I in any way condone it, but we do know this happens every day. This is why you don't dip your ink in the company well. Dorsey told the outlet her relationship with Wright began in 2010 and lasted intermittently through to 2021. 11 years they were in a relationship. And that the pair engaged in sexual activity only when she was in a subordinate professional role to him. Landry, who said her relationship with Wright began in 2010 and lasted intermittently through 2016, okay. So apparently he was in a relationship with two of them for at least, 6 years. She was told that she too only had sexual contact with him when she was a student or employee of his. Dorsey and Landry did not immediately respond to Insider's request for comment, but indicated that Law 360 that they believed their relationship with Wright were part of a larger pattern of behaviour involving many other women. Wright vehemently denies the allegations. In a statement emailed to Insider, he said that every relationship he has ever been in was 100% mutual and consensual. I'm fully accountable for the decisions I made as an unfaithful husband, he wrote in a statement to Insider, adding that he has learned from his mistakes and is remorseful to his ex-wife and family. As an attorney, public servant, and academic, I have never let any relationship impair my professional duties. 8 women total, including former students and colleagues of Wright's, have come forward with their own accounts of his misconduct. But doesn't the company buy the ink so he can do the work? Jay, yeah, he was married and there were 8 of them apparently. Following an exhaustive investigation by the university into Title IX allegations initially made against Wright 2 years ago by Dorsey and the publication of the Law 360 article, he resigned from his position at George Mason University earlier this month. The Title IX complaint, according to Law 360, includes allegations consistent with Dorsey's claims to the outlet. Representatives for George Mason University confirmed Wright is no longer employed at the school and declined to comment on the specific personnel incidents. Still, they stated the school is confident that when prohibited conduct in this matter was brought to their attention at the law school, they acted in accordance with the applicable university policies. The law school is deeply concerned by the allegations, and they aspire to have a zero tolerance of such conduct. Well, no shit. What if the company is Hooters? Fire them first. Don't do that. That is not legal advice. Being a dirty bastard is not against the law. No, but abuse of positions of power is. So, Chicken Little, just be careful if you decide to date any employees, just saying. While I make no excuses for my personal shortcomings, I stand by my character and career. Probably could have left character out of there. Will always fight for the truth and will vehemently defend myself against baseless lies spun in as a scheme for personal financial gain and notoriety, he said in a statement to Insider. In addition to resigning from George Mason University, he writes in the lawsuit that he lost clients and contract work at his law firm. The financial losses, in addition to the emotional distress he alleges he has sustained, warrant the $108 million he's seeking from his accusers. The complaint characterises Dorsey and Landry as scorned former lovers who have embarked on a vendetta to destroy his reputation, portray themselves as Me Too victims, and make a fortune in the process by making their accusations public. Mandy, I don't believe you. The legal strategy Wright has employed is part of an increasingly popular reliance on defamation claims to combat allegations of abuse and misconduct, 3 legal experts told Insider. See, the irony is I see this as a legitimate legal strategy. Because we know that allegations made against an individual, when they remain unproven or if they're just hanging out there, will destroy someone's reputation. We know this. We've seen this. We've seen what's happened in the past. I think this is the natural progression of what has to happen. I don't understand why this is a why this is a thing. What's the point of being a middle manager then? I run a small business in Danistan, thinkest thou can afford employees? Well, you know. All I'm saying is be careful in case you ever hire a contractor or something, okay? I'm looking out for you, buddy. Examples can be seen in high-profile cases like Johnny Depp v. Amber Heard, the countersuit to Donald Trump and E. Jean Carroll, the surviving families of Sandy Hook victims v. Alex Jones, and Dominion Voting Systems v. Fox. And yeeted. We're seeing more defamation cases. It was a claim that was seen as difficult to bring, but as lawyers experience success, we see more lawyers willing to take the risk, said Tracy Pearson, a legal analyst, to Insider, adding that lawyers will frequently consider their odds of success when considering whether to take a case. Well, yeah, damn straight, we kind of have to. Wright's case is similar to Depp's in that the misconduct allegations were published through the media. Both Wright and Depp opted not to sue the applicants for amplifying the accusations against them, and instead sued the women behind the claims. Ultimately, Depp won $10 million in compensation and $5 million in punitive damages for his defamation case against Heard. In a countersuit alleging Johnny Depp's lawyer defamed her, Heard was awarded $2 million in compensation. Historically, lawyers have shied away from defamation cases because the legal standard of actual malice, which is required to win a defamation case against a public figure, was regarded as a high threshold of proof, said Trey Lovell, an attorney with the Lovell firm. Additionally, some states have provisions that prevent retaliatory lawsuits from being filed, called anti-SLAPP, which we know all about. Virginia, where the case was submitted, has weak legal provisions in this area, as litigators and free speech watchdogs have noted, since the state law does not identify procedures to allow defendants to invoke the protections, and that an anti-SLAPP defense can only be invoked at a jury trial, not in pre-trial stages as in other states. Is it Labor Day? No, it is not. Our Labor Day is earlier in the year. The holiday we had, holiday. Yesterday was Father's Day. It's just a usual Monday. Just don't hire chicks or gay dudes, problem solved. Well, it depends whether or not you... Never mind. And juries appear to be more receptive to ruling on behalf of defamation claimants, especially after big wins in cases like Depp's, Lovell told Insider. So complainants like Wright may see defamation charges as a chance for significant payout and an opportunity to share their side of the story. By showing he's going through the legal system and going after them for $108 million, it makes a statement, Lovell said. People are going to take a second look at it and they're going to read the complaint. They're going to read his side, as well they should. No, both sides of all matters should be considered before making a judgment. That's the long and the short of it. Lovell added that reputation management is often a critical factor in defamation filings like Depp's, and said Wright's maneuver to file a defamation suit is a similar attempt to control the narrative that Dorsey and Landry had shared about him. Lindsay R. McCassin, an attorney from Binnell Law Group who was representing Wright, said in a statement to Insider that Wright filed suit to set the record straight. Kind of sucks that he has to, though, doesn't it? These cases are rarely about monetary damages and are more often about a vehicle to repair a vehicle to repair a reputation. That was Johnny Depp's goal. She added that there was always a risk in bringing defamation cases that the person alleging defamation will further damage their reputation through litigation. Sometimes plaintiffs, in their desperation to clear their name, fail to recognise the bad facts. Johnny Depp's case was essentially a marital dispute. This case is different because there is a power difference between the student and the professor. Yeah, which is why it's not actually going to look good, to be perfectly honest. How dare Depp? People actually now have to confirm stories instead of just blindly believing them. Where is that? Okay, you got me. Wright is seeking a jury trial. While it remains unclear if the case will reach that point, the women, now with successful law careers of their own, say they're no longer afraid of how Wright could influence their careers. I have so many thoughts about this lawsuit, many of which have been expressed by those who have been commenting on this today, so I won't repeat. Landry wrote on social media in response to Wright's defamation complaint being posted. The one thing I'll say is that I refuse to be bullied into silence. Yeah, they were in a relationship for 10 years. Oh, and I believe that's the lovely lady, the Overlaw'd. Hello. Hang on, I haven't turned the camera off yet. What's up?
Well, you don't want me on screen like this.
You're still not feeling well?
Do I sound like I'm good?
What's up?
I just called Corinne.
No, she was not whooping my ass and I was not in trouble. We're running a little bit behind on getting the little lady Overlaw'd set up for school. And we've organised to do a school tour tomorrow because we have to do that before we can actually enroll her. So, work me up with your wheezing, you bloody bogan. Oh, bite me. As a woman, I know women who have used sex to manipulate men. I'm sorry, but it goes both ways. Okay. So look, and I mean, this one will be interesting. I mean, I've got the complaint here. Let's have a look. How long is this? Oh, it's 26 pages. Maybe I'll just skim over the important parts. He's an attorney, became a law professor in 2004, resigned from the position in summer of 2023. Throughout his teaching, others have repeatedly recognised the care and dedication that he offers his students. During his nearly 20 years at GMU, Wright supervised more than 100 research assistants and taught thousands of students. Okay, and how many of them did he bang? GMU Law promoted Mr. Wright to assistant professor in 2005. Federalist, blah, blah, blah. Dorsey's long-standing history with Wright. While teaching at GMU, Mr. Wright met defendant Dorsey. Eventually, they began a romantic relationship. Both were married at the time and were well aware of each other's marital statuses. Mr. Wright and Miss Dorsey maintained a close relationship over the next 11 years, sometimes in a romantic capacity, sometimes not, but always as close friends and colleagues. Throughout that time, and regardless of the status of the romantic component of the relationship, Mr. Wright always supported defendant Dorsey's career. This is not sounding good for her. Reminds me I need to call my cousin Felicia and hang up on her. It's been a minute. Hopefully only the hot ones. When defendant Dorsey left law school in 2012, he wrote a letter of recommendation for... Wait. Okay, so they met in 2010 or 2011. I'm trying to get the timeline right here. So he met her halfway through law school, wrote her a letter of recommendation, and for another 9 years after that, they had an on and off again relationship. And she's claiming that that was because he was in a position of power over her. I call bullshit. A letter of recommendation. She was great in bed. When she left law school in 2012, he wrote a letter of recommendation. When she finished her clerkship, he helped her secure interviews with several firms, including Wilson, Sassini, Greenwich, and Rosati. Sounds like someone found out that he was assisting her, and now she's pissed off. Is this woman one or woman two? Woman one so far. At various points throughout their on and off relationship, the defendant asked for help because she wanted to leave antitrust private practice. Mr. Wright continued to support her in any way that he could, helped her interview with different think tanks, as well as government agencies, including for key positions at the FTC and the Antitrust Division of the Department of Justice. She wanted to work for a 3-letter agency. Her credibility has just dropped 3 notches in my opinion. When defendant Dorsey left the DOJ, she again sought career advice from him. She was unsure if she wanted to enter academia, move to an in-house counsel position, return to private practice, or to go to graduate school. In response, he set up opportunities for her to talk to academics, created and raised funds for an academic fellowship, and made a variety of calls to supporting her in-house, including at Amazon. So an affair with a co-worker. Okay. During the period that they were at law school, he was her teacher. So for 2 years, that's an inappropriate relationship. The fact that this has gone off and on sounds to me like she was whoring herself out for career advancement. She took advantage of him. That is what it sounds like. And now she's, at least in this circumstance, and you've got to remember, this is her own damn document. This is her complaint. This isn't his defense or anything. This is the information she's putting in, and it's really not making her look good, in my personal opinion. It seems like every time she needed help, she went back to him, and it was sort of a quid pro quo. In 2020-2021, he helped her attain the fellowship with UVA, and she took consulting work from his firm as an independent contractor to help her financially while waiting for her fellowship at UVA to begin. Mr. Wright and defendant Dorsey also published academic papers together, at least 6 over the course of 4 years, and worked together at GMU and elsewhere. During the course of the relationship, the two travelled dozens of times. Keep in mind, they were both married at this point as well. Everyone who's smart knows you never date your co-workers. This is true. Like I said, don't dip your pen in the company wink. Don't dip your pen in the company ink. She told Mr. Wright then that you're the person I want to... Wait, what? In 2021, she confided in him about personal matters such as finding out that her father was not her birth father and her feelings of loss after her aunt passed away. She told Mr. Wright then that you're the person I want to talk to for everything good and bad. Defendant Dorsey also confided in Mr. Wright on 2 separate occasions that she'd been SA'd by 2 different members of the antitrust bar. Mr. Wright believed her at the time. In the company wink. Yeah. Eventually, in late October 21, Mr. Wright ended an on and off relationship with defendant Dorsey in a text message telling her that he was seeing another woman. And he also told her who it was. Don't dip your coin in the boss's daughter. Jesus Christ, porcelain. This is really not sounding too good for her. Like, I kind of hope that this... Like, I know it won't be, but imagine if this was streamed. The other woman, who is now Mr. Wright's living girlfriend, was not just another woman. Defendant Dorsey had previously worked with her at the same firm. During that period, Mr. Wright and the other woman had been in a romantic relationship. Defendant Dorsey knew about the relationship at the time, which overlapped with her own romantic relationship with Mr. Wright, and she hated her. Defendant Dorsey was incensed. She immediately responded in a text message, What the actual fuck? You know I deserve better than a text message right now. She proceeded to send a series of angry text messages, included, "You promised me multiple times you would be here, but you're doing the opposite. You're abandoning me in the worst way possible. That's straight fucked up. I'm so embarrassed for thinking you ever respected me, let alone love me." Okay, this is now just sounding like a very scorned woman. Yep, there it is. Seems like a 1 out of 10 of my co-workers met their spouse at work. Huh. "I didn't think I could hurt this much. You're so mean to me. I don't know why. I need you at minimum to call me because right now I could not possibly think less of you. You say you're all about loyalty. Show it right now for once." She concluded with her disdain for the other woman. "I mean, I get you not wanting to see me, but you're going back to her after how horribly she treated you, your family, everyone you say you care about." Within days of sending the above text messages, defendant Dorsey came uninvited to the law school, waited outside one of his classes, and then followed him to his office. Once in the office, she yelled at him loudly regarding the end of their relationship and demanded to have a conversation with him. Several people overheard her yelling. After Mr. Wright refused to have a further conversation with her, Miss Dorsey repeatedly tried to contact his girlfriend with several calls and text messages, which were unwelcome by his girlfriend. Yeah, she has abandonment issues. Oh, what am I talking about? This is his document. Oh, I'm a moron. I forgot this is his defamation claim. This is not her sexual assault claim. I thought this was the initiating document against her. This is okay. This makes so much more sense. I got very little sleep last night. Not that that's an excuse. After Mr. Wright refused to have a further conversation with her, defendant Dorsey repeatedly tried to contact the girlfriend, blah, blah, blah. Ultimately, the persistent and aggressive conduct made Mr. Wright fearful for his safety and his children's safety, as defendant Dorsey had proven herself to be extremely erratic and unpredictable. Her conduct persisted and worsened. In retaliation for the breakup, defendant Dorsey embarked on a premeditated plan to ruin his life. Having been one of his closest confidants and lover for over a decade, and having insider knowledge of his employment and his major clients, she knew exactly where and how to hurt him professionally and reputationally. Within 2 months of the breakup, she also filed a false Title IX complaint against him with GMU on December 12, 2021. In it, defendant Dorsey took horrific and obvious lies of sexual harassment to the Title IX office. The facts of their long-standing, obviously consensual relationship be damned. Defendant Dorsey portrayed Mr. Wright in her Title IX complaint as a sexual predator and herself as a victim. Given their decade-long history, they're traveling the world together and they're sharing the most intimate details of their lives, including both of their prior marriages, these allegations were patently ridiculous. Defendant Dorsey also falsely stated that the Title IX office that she ended the relationship with Mr. Wright. He took adverse actions against her to retaliate for terminating the relationship. As shown by the text messages and the fact that he never took or even had the power to take the retaliatory actions she alleged, that was also a malicious lie. Go drunk, you're home. $50 on her using a 3-letter agency contact to contact other women and concoct a scheme. That is certainly not a bet that I would want to take. Do I need to give Glowy a wrench? Next, defendant Dorsey attempted to recruit other former girlfriends of Mr. Wright to join a crusade. She successfully recruited defendant Landry. Multiple women have informed Mr. Wright that defendant Dorsey or defendant Landry both have tried to recruit them to falsely accuse him of sexual misconduct. Huh. That's going to be interesting. Defendant Landry, like defendant Dorsey, had engaged in a consensual sexual relationship with Mr. Wright that began at some point between 2009 and 2012, during which period defendant Landry was already in a long-term relationship. It ended in 2012 and then resumed in 2015. It seems like everybody was like... What? YouTube recommends below, Gordon Ramsay tries cheesy shark soup. Kitchen nightmares. Huh. There you go. Am I handing out wrenches? Not at the moment. When the relationship... where did I get to? Defendant Landry left the FTC. Oh, hang on. Wait a second. Landry and Dorsey both worked at the FTC? Then resumed in 2015 when defendant Dorsey took a job at the FTC. Defendant Landry left the FTC in September 2015 to join a prestigious international law firm, while their relationship with Mr. Wright continued into 2016. When the relationship ended, also like defendant Dorsey, Landry did not take it well. In a series of text messages in December 2016, Landry tells Mr. Wright, "You were the one who told me you didn't want to be with me after 5 years, and you were what I wanted, and you couldn't be with me." Despite this bad breakup, defendant Landry apparently decided to remain on good terms and even reached out to Mr. Wright when she was having professional difficulties. In January 2019, when Landry was apparently being pushed out of her law firm, she sent Mr. Wright emails confiding in him and seeking his help. She wrote, amongst other things, "Hi Josh, still trying to wrap my head around all this. Hope you don't mind me leaning on you right now. Your support and advice mean everything to me. Also, I'd like to talk to you about the GAI position that's open. I've been thinking for a long time about asking you if there's any potential for me to work there. And I saw your tweet the other day about an actual opening. Maybe it's serendipity." Wow, so she was trying to... Hayden won't even fire me. I can't apply for moderator unemployment and be lazy. It isn't fair. She was basically trying to use her relationship with him to get a job. Well, Mr. Wright responded he'd be happy to meet, but he was stuck in Florida Keys. Defendant Landry responded, "Oh my god, stuck in the Keys. Definitely disaster. I'm so sorry. Let's get together later in the week. I'm going to work on my resume and stuff, and also work tomorrow. Excuse me. Just let me know what works for you. My schedule's pretty open." They met for coffee. When Landry continued to struggle to find a job, Mr. Wright provided her with encouragement. Most importantly, keep your head up, blah, blah, blah. As late as March 2019, defendant Landry sent Mr. Wright a series of emails in a very casual tone containing emojis and elongated words like "hi," which was clearly friendly and cordial. Apparently, however, defendant Landry's friendly demeanor was reserved for times when she needed something from Mr. Wright. In approximately February 2020, Wright heard from his then and current girlfriend that defendant Landry was still angry and had been saying derogatory things about him and their prior relationship. Mr. Wright's then and current girlfriend, who was close with defendant Landry, so close she officiated Landry's wedding, asked him to make amends with Landry. When he attempted to do so, Landry was clearly still raw about the relationship and said once again that "I was willing to do anything to be with you." Her schedule wasn't the only thing that was open. These words and those from December 2016 are not of someone who was pressured into being in a relationship with Mr. Wright, as she's now claiming. These are the words of a scorned woman who had strong feelings for him. He better hope he gets an all-male jury. Defendant Landry was therefore primed and ready to join defendant Dorsey's attack on Mr. Wright. The two of them met as early as January 1, 2020 and agreed to take acts jointly against Mr. Wright. Amongst those, defendant Landry made false allegations to GMU's Title IX office in support of defendant Dorsey's complaint. Alright, I'm only halfway through this, hang on. Falsely told one of his clients that he was prohibited by the American Bar Association from participating in professional events, and that he had sexually harassed multiple students, or at least that he was under investigation for the same... Oh, that's going to be interesting. He's going to have to subpoena former clients. Defendants repeated the same lies that told the GMU, including that he sexually harassed them, or at least indicated to his clients that he was under investigation for sexual harassment, which was a thinly veiled way of affirmatively signaling that he did in fact sexually harass his students. As a result, many of his clients, not wanting to be associated with the claims, terminated their relationship with him, costing him hundreds of thousands of dollars. The client suspended business relationship, costing Mr. Wright approximately $600,000 in lost revenue per year in contracts that would have ordinarily renewed, if not grown in scope, every year for the foreseeable future. Further, Mr. Wright had an expert consulting contract with Kirkland and Ellis LLP. Approximately July 22, shortly after defendant Dorsey began working at Kirkland, she falsely told the attorneys with authority over Mr. Wright's contract that he had sexually harassed multiple students. Oh, for fuck's sake. Did she deliberately get the job there just to tell him that... Kirkland immediately terminated Wright's contract, causing him substantial financial loss and reputational damage. Additionally, defendants spread their lies to practicing attorneys in the antitrust bar, from which Mr. Wright gained significant revenue through referrals. Defendants falsely told at least one antitrust lawyer in an effort to recruit her into this scheme that Mr. Wright had sexually harassed them. After spreading lies within the professional circles, defendants Dorsey and Landry, through their shared attorney, made a multi-million-dollar demand to keep them from further ruining his reputation with a meritless lawsuit. On the very day that Mr. Wright refused to pay what he viewed as an extortionate demand, the defendants created Twitter accounts. As if taken from a plot of a bad movie, Dorsey's first post on her newly created Twitter account was, "I held out as long as I could, but I now have things to say," with a meme showcasing actress Amanda Bynes in the caption, "I'm very pleased and scared to be here." Oh, for God's sakes. This teaser was no doubt created to draw people into a story that was about to be shared worldwide on the internet. Defendants Dorsey and Landry began following high-profile accounts in antitrust law and journalists to cause maximum harm to Mr. Wright when they shared their false stories. The defendants contacted Abra Co. with Law 360 to publish their story. Law 360 agreed and published a story on August 14, 2023, titling it, "I Suffered Silently, Ex-Law Professor Allegedly Preyed on Students." Once published, it took the legal world and especially the antitrust bar by storm. It was shared countless times on social media, harmful memes were created, and the public devastation began. What was it called? "I Suffered Silently." Okay. There it is. She doesn't know how to hold it. Oh, I'm not signing up just to bloody read that article. Are you kidding me? Once published, it took the legal world by storm. After Law 360 published a story, many of the news platforms began publishing stories of their own based on what was stated in the Law 360 article, as generally happens. List of these news organisations includes, but not limited to, the Daily Mail, Law.com, and Above the Law. And the Aussie Overlaw'd show, apparently. If they worked at the FTC, why aren't they complaining about the rampant furry orgies? It's a good question, Abomination. The Law 360 article, attached and incorporated in Exhibit D, contains numerous lies and omissions which, taken as a whole, created and were intended to create a false implication that Mr. Wright abused his position as a law professor to pressure defendants into having unwelcome sexual relations with him, and that he retaliated against them as a result of ending their relationships. For example, in the article, defendant Dorsey claims that, prior to any sexual relationship, Wright essentially tricked her into accompanying him to what she thought was a platonic business trip in California to meet with clients, and then, to a great surprise, found that when they arrived, there was only one room and one bed, and that there were no client meetings. She claims that in the hotel room, she didn't feel like she had a choice to engage in sexual contact with him, and which she claims was the first time they'd been intimate. Hayden Smith, give us your social security number to continue. I'll be right. This account was a lie. While the trip itself did happen, defendant Dorsey and Mr. Wright were already in a romantic sexual relationship, which changes the entire context of events. The trip was not some ruse to get defendant Dorsey into a hotel room alone. It was a romantic getaway for two lovers to spend time in the wine country. Defendant Dorsey's false account is straight out of a bad movie and is intended to portray Mr. Wright as a sexual predator and herself as a victim. Dorsey also claims in the article that Wright pressured her to keep the relationship a secret. They were both married. She was going to keep it a secret one way or another. This is similarly misleading as it leaves out the fact that defendant Dorsey also expressed her desire to keep the relationship secret since both of them were married. Once again, defendant Dorsey creates the implication that secrecy was one-sided and it was intended by Mr. Wright to exercise power over her, when in reality, the desire for discretion was mutual for two consenting adults who were both married and did not want their respective spouses to know about their relationship. Dorsey leaves out the crucial context of their 11-year history of close and intimate relationship. She leaves out the fact that she continued to be involved with Mr. Wright long after graduating from law school. She knowingly took jobs working at the same company and would resume their romantic relationship, even when they were not at the same company. Can I awaken a lady overlord again? No, I've got to be quiet. She's on a call. While defendant Dorsey describes confronting Mr. Wright about an affair with another former GMU law student, she fails to mention that this person was not just some former GMU law student, but was a romantic rival, a woman who also had a long-term on-and-off-again relationship with Mr. Wright, which had overlapped with defendant Dorsey's romantic relationship. Once again, Dorsey intends to portray Wright as a sexual predator, but in reality, this is about a love triangle amongst consenting adults. I'd like to report a mutiny. J. Liebgett is going mad with power. She creates a false impression this was an affair that was something new that she had just learned, when in fact she'd known about the relationship for many years, and that she was upset not because this was a former GM student, but because it was a romantic rival, and that Mr. Wright had chosen her over Dorsey. Indeed, defendant Dorsey was well aware that Mr. Wright and this former GMU student were still together in a committed relationship, and she intentionally leaves out the information to create a false implication that Mr. Wright preys on students. Retaliated against her after she ended the relationship. Similarly dishonest, she claims that she felt she couldn't say no to Wright. Shown in the multitude of texts and emails, defendant Landry maintained her consensual relationship with Mr. Wright over years after graduating and was upset when the relationship ended. This is why you don't date multiple women at the same time. Are you serious? Abomination says, I wish I could have a sexual predator that travels the world with me. Get a fish. Defendant Landry then tweeted that Mr. Wright was the Harvey Weinstein of law. That of itself is defamatory, unless she can prove it's true. Holy shit. Intending to and creating the impression that Mr. Wright was a vile predator who forced women to have sex with him. I've called him that, told him it to his face, and he continued to continue the conduct years after. Holy shit. Defendant Landry implied in the Law 360 article that Mr. Wright never assisted her with work or professional connections after their sexual contact ceased, stating once he was done with me, those things stopped coming. This is demonstrably false, as shown by emails and text messages between the defendant and Mr. Wright in 2019, when, well after any sexual relationship had ended, he went to great lengths to assist her in her time of professional need when she was pushed out of her law firm job and seeking advice and new employment. Article also reported that GMU has a consensual relationship policy. Notably, the consensual relationships policy is a disclosure policy that went into effect on January 28, 2012. Defendants Dorsey and Landry graduated in May 2012, and therefore the policy was not in effect at that time. As a result of the publication of the article, Wright lost renewing contracts with multiple major consulting companies and employers with a total value of approximately $1.15 million a year. Continues to suffer damage and loss. Alright, so then he's claimed that the article is defamation, which I'm inclined to agree with him. Tortious interference with his business because they went out of his way to talk to clients. Statutory conspiracy. Common law conspiracy. Prayer for relief. Plaintiff Joshua Wright, by counsel, demands judgment against the defendants, an award of compensatory, special, and punitive damages of $108 million. $108 million. Plus prejudgment interest. Injunctive relief prohibiting the publication or republication of defamatory statements, an award of plaintiff's costs associated with this action, including but not limited to his reasonable attorney's fees and expenses, and such other reasonable fee relief as the court deems just, fit, equitable, and proper. So there we go. And we don't have any of the exhibits, otherwise I would happily show them. But this is interesting. It's interesting seeing how people are up in arms about the fact that someone's claiming defamation against someone that has potentially, and I'm going to be potentially and say alleged and all this sort of shit, claim sexual harassment against him. If even half of what he said in this complaint is true, though, it does really seem to me as if it's two women that are still scorned, and I hope to hell he gets an all-male jury. I really do. Because any chick that's been wronged, that's ever had a boyfriend that's ended a relationship, or that, you know, are just generally cray-cray, are gonna see him. He's gonna lose out. So, but I mean, look, it's what Fairfax County in Virginia, so it'll be interesting to see. What's that? I hope he gets all of it from the. What is that? Bunny what? Bunny barbecue? Okay. Alright, that's fine. hell is that? Okay. Anyway, all right, I'm going to finish it up there, guys, because we're at the 2-hour mark. I went a little bit longer than I intended to. So, have Law and Lumber follow. Well, I'm going to follow it, but I may have him on. I mean, it is potentially up his alley. We'll see. But as always, guys, please remember, you are not a piece of shit. You do have value and you do contribute to society, especially if you follow me on Twitter. Double check whether or not you have liked this stream, whether or not you are still subscribed, because somehow I'm fluctuating around 15 a day again. But yeah, you are not a piece of shit. You do have value and you do contribute to society. And please stay healthy, wealthy, and wise. And I'll catch you all later. Cheers, guys. Why is my chair vibrating? Literally because my leg shakes. That is nothing to do with the chair, and its hands are above the desk, if anyone's concerned. But, yeah. Where are we?
This shit, I'm out. Fuck this shit, I'm out. No thanks. Don't mind me. I'ma just grab my stuff and leave. Excuse me, please. Fuck this shit, I'm out. Nope. Fuck this shit, I'm out. Alright then. I don't know what the fuck just happened, but I don't really care. I'ma get the fuck up out of here. Fuck this shit, I'm out.